It is my great pleasure to introduce the Chief Counsel for the Pennsylvania Family Institute's Independence Law Center, Randall Wenger, who is joining us. And then from the Office of Civil Rights at the Federal Department of Health and Human Services is Matt Bowman, Attorney Matt Bowman, who's joining us as well. And I welcome both of you to this webinar. And I'm going to first start off by setting the stage here a little bit. First, to talk about back in August of 2011, actually going back about a year before that, the Affordable Care Act was signed by President Barack Obama. And as regulations were being promulgated for that law that went into effect, passed in Congress by a 100% vote of a party line vote, the passage of the Affordable Care Act, then went into effect, or as it went into effect, different regulations were put forth. And in August of 2011, was put in what is commonly referred to as the Contraceptive Mandate. And what the Contraceptive Mandate basically said is that employers under the Affordable Care Act that were providing their employers of a certain number of employees, certain size companies and organizations, were required to provide coverage, insurance coverage for their employees that included contraceptive coverage. They called it the Contraceptive Mandate, or sometimes it's called the Obama Mandate, or the HHS, or the Obama HHS Mandate. In any event, as that went into effect or was announced, a lot of people, including our own attorney at the Independence Law Center, said this tramples on religious liberty. And when the Obama administration realizes what they have done, they're going to quickly rescind this. And Randy, I don't know if you want to take it briefly from there and then what happened from that point.
Well, yeah, I just thought it was a mistake. I thought that the Obama administration just didn't know enough about pro-life conservatives and the religious liberty problem that was going to cause for a whole host of Americans. So I just thought, oh, they made a mistake. And that often happens in the policy realm. You see folks making a mistake and then they somehow figure out a way to save face and backtrack and everything works out. But that wasn't that easy. It wasn't that easy at all. And we soon found out that faith-based organizations, whether they were nonprofit organizations or friends like the Hahn family at Conestoga Wood Specialties here in Lancaster County, Pennsylvania, were subject to the same mandate, where they were being told that they needed to provide drugs and devices that could result in an abortion as part of the healthcare plan. And for pro-life business owners, that was a bridge that could not be crossed.
And so I remember in those early days after this mandate came down, attending a meeting that was convened by then Congressman Joe Pitts, who represented parts of Lancaster and Chester counties, calling together people from the religious community, from organizations and ministries and things, to say, hey, this appears to be a problem, a conscience problem, and we're going to push back against the Obama administration, see if this would be changed. They didn't change it. They dug in their heels and stuck with it. So then fast forward, you mentioned the Hahn family, fast forward to an event, Pennsylvania Family Institute event in that next year in 2012, and heard about the concern of the Conestoga Wood Company and the Hahns. So take it from there, then that one ended up in court, right?
Yeah, we sat down with the Hahns. We talked about what was happening nationally at that point, and there was a case that was very colorfully described as Hercules versus Obama. A company out, I believe in Colorado or thereabouts, and they had got an injunction. And I thought, oh, this is easy. This makes sense because we respect religious liberty in this country. This can't be that hard. Of course, the court got it right, and called up Matt, who was working at Alliance Defending Freedom at the time, got his advice on how to move forward. We, with the help of our friend Chuck Proctor, filed a lawsuit on behalf of the Hahn family in Conestoga Wood. We got a temporary restraining order in our favor and thought, of course, this is going to be easy. And then everything changed. And it was a very difficult case after that point, because the court kept saying corporations don't have any religious liberties, and so you can't even get onto first base on these cases. And why does it bother you anyway? It's employees' decisions about what employees do with their contraceptive coverage, not really understanding the conscience implications or how conscience works. That my conscience may not function the same way that Matt's conscience functions or that your conscience functions. But there was no room for these business owners to just follow their conscience. So it got lost in the district court. We lost 3 times in the Court of Appeals before we took it up to the Supreme Court. We worked with Matt Bowman and Alliance Defending Freedom, and we got a tremendous victory where the U.S. Supreme Court recognized that corporations have religious freedom, and recognized too that the mandate that was being applied to Conestoga Wood violated the Religious Freedom Protection Act. So it seemed like we won, but things are not always that easy.
I think maybe you're seeing a picture there of Anthony Hahn from Conestoga Wood Specialties there on the steps of the Supreme Court the day that the case was argued.
Yeah, that's one of my favorite pictures that we have hanging here at the Pennsylvania Family Institute, remembering that colorful day. And it's a picture of, in my mind, of just the diverse nature of who we are as Americans. So we have my friend Anthony Hahn, who's a plain Mennonite, standing there in front of all the cameras in front of the Supreme Court, which I know was not where he likes to live his life, but he also knew that by taking a stand for religious liberty, that was going to be something that all kinds of Americans were going to benefit from for their conscience.
Well, I remember those days vividly. In that case, the win came down from the United States Supreme Court, Justice Alito, with a great decision. I don't know, Matt, if you want to comment on that decision that came down, or I don't know, honestly, what, as a government attorney now with the Department of Health and Human Services, what parameters you have to talk about things like that. But I certainly appreciated that case and what came down, and thought, okay, this issue's settled.
And
sure. Well, it's a matter of historical record, what the Supreme Court decided in that case. And thank you, Michael and Randy, for having me here today. In my previous life, before I joined the government, I was at Alliance Defending Freedom and was honored to serve with you, Randy, on behalf of the Hahn family and Conestoga Wood Specialties, which the Supreme Court highlighted in the Hobby Lobby decision. It was a case filed with Hobby Lobby and the Green family. And Justice Alito, who wrote the decision, spent a lot of time talking about the Hahns and their faith and how they exercise their faith in their business.
And I'll add that Justice Alito talked about the Hahns before he talked about the Greens. Not that we're keeping score or anything.
It was a key point in the decision to speak about both families and how they exercise their faith in business. And was with that background that I, in January 2017, was asked to join the Beachhead team, the set of first appointees of President Trump to come into the administration. And we landed, if you will, on Inauguration Day here at the U.S. Department of Health and Human Services to implement President Trump's agenda. And an important part of his agenda was his promise to protect religious liberty. And
I just want to punctuate for the people who are watching what an amazing thing that this is. The very attorney who was working on this issue while at Alliance Defending Freedom, when we had the case Conestoga Wood and were first filing the papers, all of the help that you were giving me behind the scenes, you cared deeply about this issue, but you were the litigator. And then suddenly you were brought into HHS to be able to help from the inside. And what a tremendous encouragement it was to those of us who litigate to see somebody like you being put into a position like that.
And to be clear, all ethics requirements about specific matters were followed here as President Trump demands of all his political appointees, and so there were no I didn't, for my first 2 years here, I didn't work on any cases I had worked on when I was at ADF, and there aren't really any of those cases left now. But general matters, certainly I was allowed to work on under the ethics rules. And again, President Trump brought in not just me, but thousands, literally, of people to implement his agenda across various agencies, not just at HHS. And again, a key part of his promise was to protect religious liberty, and a key part of that was keeping his promise to people like the Little Sisters of the Poor and the Hahn family and others.
And let's talk a little bit about Little Sisters of the Poor. There were some things that happened between the Conestoga Wood Hobby Lobby win and you finding your way at HHS. So after the win at Hobby Lobby and Conestoga Wood, the Obama administration said, okay, we can't apply this mandate to organizations like Hobby Lobby and Conestoga Wood, but there were others, including faith-based organizations, that were being given what was called an accommodation. And that accommodation was, hey, you don't have to have this as part of your healthcare plan, but you need to let us know if you're not going to have it part of your healthcare plan so that we can add it as part of your healthcare plan. And just kind of this shell game that occurs on the policy level in the Obama administration to basically make the same thing happen again, but claim that it's not happening again. And so groups like Bishop Zubik from here in Pennsylvania and Little Sisters of the Poor challenged that and found their self back at the U.S. Supreme Court in 2016. Can you talk about what that case was about?
Yeah, there was essentially a stalemate between the groups that didn't accept the accommodation according to their conscience and the previous administration. And in fact, in the last few days of the previous administration, they issued a statement saying, we don't know how to resolve this dispute. The Supreme Court actually remanded the case and give the parties an opportunity to settle. And they basically said in a public document, we don't know how to do that. And then President Trump took office in late January of 2017. And
somebody figured out how to do it.
Right. And a few months later, he was in the Rose Garden having a press conference with the Little Sisters and explaining that he was committed to make sure that people of conscience are going to have their religious liberty respected in implementing the Affordable Care Act, as well as other laws and policies.
And then we all lived happily ever after.
It never quite works that way, does it? But
no, it doesn't. So here in our very own dear Commonwealth of Pennsylvania, our state attorney general, Josh Shapiro, sued the Trump administration, Commonwealth of Pennsylvania versus Trump, where he took the position that HHS violated the law by giving broad religious liberty protections to groups like Conestoga Wood and to Little Sisters of the Poor. And by giving those broad exemptions, they're violating not only the Affordable Care Act, better known as Obamacare, but even violating the Religious Freedom Protection Act, which every time I think about that makes my head explode. So he ended up getting an injunction in place prohibiting the new law, the new regulations from being carried out. And so Little Sisters of the Poor intervened in that case, and the Supreme Court just last week heard arguments from the Trump administration and Little Sisters of the Poor. So typically we would be asking you, were you in the courtroom that day? But of course, nobody was in the courtroom that day, but you certainly listened to those oral arguments. Can you tell us a little bit what happened in the court?
I did, and it's actually for the first time in history, anyone can listen online live to the Supreme Court's arguments. So that's what I did from my home. And the Solicitor General of the United States, Noel Francisco, also obviously an appointee of the president, and he was confirmed by the Senate, made the argument on behalf of what the Trump administration did. And what we did precisely was all of these old lawsuits were as a result, as Michael mentioned, of rules and policies that were put in place in 2011 to implement the Affordable Care Act, which was passed in 2010. Well, rules are created by agencies, and President Trump issued an executive order ordering the agencies to respect religious liberty. And so that's what the Department of Health and Human Services did in the fall of 2017. Less than a year after the inauguration, Health and Human Services issued what are called interim final rules with requests for comment. So we issued rules, as had been done 3 times previously, that would go into immediate effect, but also request comment from the public before they were made final, to protect the religious liberty of groups like the Little Sisters and the Hans and others, even those who have conscientious objections that are not religious, but that are moral, based on moral convictions that hold the same place, a similar place as religion does in the conscience of Americans. And that's where the first injunction came out of that you referred to. And then a year after that, after receiving the public comments, responding to them, taking them into consideration, making some changes, the Department of Health and Human Services finalized those rules in the fall of 2018. And the litigation continued, and that's what happened. Went all the way to the Supreme Court and was argued last week, where the Solicitor General explained that what the administration did was lawful. And you can hear and read the explanation, but to encapsulate it, it's simply that the Affordable Care Act doesn't require contraceptive coverage in its text. Congress didn't say that in the law. What it said was prevent such additional preventive services for women as provided for in comprehensive guidelines supported by a component of HHS. And so what HHS, along with other administration agencies, did was issue rules saying we no longer provide for and support the imposition of this requirement where conscience would be violated. We're still requiring the coverage for 99% of the people who would be covered otherwise, and the Affordable Care Act doesn't apply the coverage to many plans. But for those plans where it does apply, the rule said that's still in place, but where there's a sincerely held religious belief or moral conviction against it, there are going to be certain entities that are not required to do it, and such as, again, the Little Sisters of the Poor or the Han family at Conestoga Wood Specialties, not by name, but by category. So the categories were identified, and the argument was, well, if the Affordable Care Act said the agency can provide and support whatever guidelines it wants to provide and support for, and the last administration did it one way, we can do it this different way. We had good reason to do it because we've been in court over this for almost 10 years. And the Solicitor General asked the Supreme Court to lift the injunction and let those regulations go into effect.
You are muted, Michael.
I hit my space bar. I was supposed to unmute me, but it didn't work. I do this at least once per Zoom, so I'm keeping track. I just want to welcome the audience, people who've joined in or people who may have questions that want to ask of our attorneys, Randall Wenger from Chief Counsel of the Independence Law Center, and Matt Bowman from the Office of Civil Rights at the Department of Health and Human Services are our guests today on this Live at Lunch webinar by the Pennsylvania Family Institute. If you have questions, you can use the Q&A box at the bottom of your screen if you're using a normal Zoom app, or you can put questions in the chat box, and I'll try to keep watch of those and ask them of our panelists, our distinguished attorneys that are joining us today. Randy, I wanted to toss it to you because you listened in to the oral arguments as well. None of the attorneys or people had to sleep outside on the sidewalk to get into the Supreme Court as you did for the Conestoga Wood case, or your kids did actually for some of us. The big long lines that wait to get in the court for those significant arguments that are made before the Supreme Court. I even listened into the court as well. I wondered if you would comment about what you heard as well. And I wanted to mention, I was talking to my wife, we were both listening because I'm working remotely from home, listening to attorney Paul Clement, who argued for the Little Sisters of the Poor. And his name rang a bell with me because he was the guy who argued the Hobby Lobby Conestoga Wood case ultimately before the court. And I said to my wife, he's an amazing guy. I said, he's probably standing there or wherever he was on his phone. At least when he argued Conestoga Wood, he had no notes in front of him. He was doing it all from memory, taking these questions and stuff. And I was impressed even with his performance there as a non-lawyer watching it. But I wanted to get your impressions as well.
Yeah, well, watching or listening to Paul Clement is always a good experience. Not having notes doesn't mean he's being lazy. Not having notes means someone who argues at an appellate court about once a week and knows what he's doing and has such a tremendous memory, apparently doesn't need notes like I do. But I was very impressed with the way the case was argued. I'm hopeful. I'm hopeful for the outcome, but I was kind of struck what a difficult argument the other side had. If I was to choose a side just based on without really caring the outcome, but just listening to the arguments made, I would much rather take what our side was arguing than what the other side was arguing. And I was just wondering, Matt, listening to Pennsylvania's Attorney General's office arguing that case, how can they win if the Affordable Care Act itself does not actually, in its text, does not actually require the abortifacient coverage? It seemed that even Justice Breyer, who's not always seeing eye to eye with us on things, was having trouble with the argument that Pennsylvania was making.
And that point, I think, was also being made by Solicitor General Francisco. And what people need to understand in that respect is this mandate has never been universal. From 2011, there were exemptions. The mandate did not apply to what are called grandfathered plans, which encompass tens of millions of people at major corporations who had no religious objection to the requirement. They just had a plan that the Affordable Care Act decided it would impose certain things on those plans, but not this, because it just decided that this wasn't at the level that they were going to impose it on all plans. And the Obama administration also provided two key exemptions. You've mentioned them. There's an exemption for churches and their integrated auxiliaries, which are the closely connected, financially supported entities to churches. But there's also what you referred to as the accommodation. And there's an important point that the Solicitor General mentioned 9 times in his argument. He referred to it as the effective exemption for self-insured church plans. And this gets a little bit detailed, but what this is there are a bunch of plans out there that cover not just churches, but a bunch of religious nonprofits. But they're set up or initially sponsored by churches. Essentially, you can affiliate if you're in that denomination, more or less. You can affiliate. I'm speaking with broad strokes here, and these plans cover hundreds of entities that aren't churches and thousands of employees, tens of thousands, hundreds even of thousands of employees. And the Obama administration did not apply this mandate to those entities. In effect, they said, well, if you fill out a form, then we're not going to force your plan administrator to provide contraceptive coverage. And they said that for various reasons, but the upshot of it is that if the plaintiffs in this case were right, that there's no authority to create exemptions, then all the exemptions the last administration created would disappear, unless you found some other basis for those exemptions. And I think they were having a very hard time to explain what they believed the basis was and why they didn't seem to be upset about those exemptions, but they are upset about these exemptions, and why those exemptions are authorized and these exemptions are not authorized. I agree with you. That was a very difficult explanation for them to provide.
Well, and in addition to that, one of the troubling aspects of their argument, not that I expect it to prevail, but arguments are often made because they're hoping that at some point it will prevail. And that was the argument that you can't give too much of an exemption without actually violating the religious freedom protection, the Religious Freedom Restoration Act, where the Religious Freedom Restoration Act itself becomes a sword used by the other side rather than a shield to protect those who need their religious liberties protected. Can you speak to that a little bit?
I think that's a really interesting point, because if you read the regulations that the Trump administration issued, they said, we went back here and we looked at the fact that this mandate has not applied to so many people, either because the statute didn't apply it or because exemptions were created. And we looked at, what would it mean to apply this to certain kinds of entities? And at least with respect to certain kinds of entities, the administration said, we no longer find that there's what's called a compelling interest to refuse to have an exemption. The administration is still requiring the coverage in general, but for entities that have religious beliefs or moral convictions against it that are covered by these exemptions, they're not. And the rules say it's because we don't have what's called a compelling interest to say to you, a particular entity that has a conscientious objection, we are not going to exempt you. We don't have a compelling interest to say, I'm not going to exempt you, but we were exempting all these other companies, all these other situations. And under the Religious Freedom Restoration Act, it says the government can't substantially burden the religious exercise of someone, the federal government is how it applies, unless the government has a compelling interest to do so and is pursuing the least restrictive means of advancing that interest. And so I think what you're getting at is essentially the idea, and this is how I would say it, that if the government has now come along and said, we don't have a compelling interest, we're not going to substantially burden these religious people. And other entities, states, have come to court and said, yes, you do. You have a compelling interest to burden these people's beliefs, and you have to burden these people's beliefs. And the fact that the federal government said, we don't have a compelling interest, therefore RFRA, the Religious Freedom Restoration Act, protects these people. The plaintiffs are using this to say, no, we can force you to agree that you have a compelling interest, and then we can force you to violate these people's beliefs. I've never seen that before. I've never seen that theory of you taking RFRA, which is a shield, and using it as a sword.
Yeah, that concerns me, because what happens 5 years down the road, 10 years down the road, if there are different people in charge of the administration, different people in charge of the Supreme Court, and those arguments actually get traction. So many out there don't seem to understand the importance of rights of conscience. And I see it all the time in the circles that we work in, but it's not just hey, religious liberty is something that protects conservative evangelicals or conservative Catholics. Religious freedom is kind of like freedom of speech. We may not agree with the speech that somebody else gives, but if we protect their right to speak, it protects a system so that all of us have our rights preserved. It seems like too many are forgetting that that freedom of religion is the same sort of thing. That if people are quick to say, yeah, people shouldn't really have a right of conscience when it comes to this HHS mandate, what's going to happen when they want to exercise a right of conscience in a different area? And so even as I've talked to the media through the years on this issue, when I talked about, hey, everybody should care about this, even people who aren't pro-life, even people who aren't religious, because if government has the power to violate people's most deeply held convictions, there's no firewall against the spread of tyranny. And then at a certain point, I'd see folks from the media that I wouldn't expect nodding their heads as if, hey, I've never thought of that before. But I think we're in jeopardy, I think, constantly of losing our religious liberty. We've seen time and time again as groups like Alliance Defending Freedom get involved on issues, as we get involved in issues, religious freedom can be protected. As we get involved in the legislature on issues that we're working on, religious freedom can be protected, but we need to remain vigilant. It's not like we can let our guard down at any point. Otherwise, it's one of those rights that just disappears. And we have folks like Pennsylvania's Attorney General making the argument that we shouldn't have broad religious liberty protections.
Well, I want to interject here, Randy, as you mentioned that because of the vital nature of working to protect religious liberty, which is under attack by, for example, in this case, the Pennsylvania Attorney General, groups like the Alliance Defending Freedom and the Beckett Fund, which was involved in this case on the Little Sisters of the Poor, the Trump administration there, but groups like those and the Independence Law Center that go to bat for groups like the Hahn family or the Little Sisters of the Poor or so many different cases. It's the folks that are joining this webinar, for example, that are supporting organizations like that with financial contributions that make these groups able to come alongside and support them. I mean, if you were to put a dollar amount on any of these cases, the Little Sisters of the Poor now being not just the first time, but the second time before the United States Supreme Court, it would bankrupt most anybody to be able to handle that. And yet, because of the financial support of people out there who say, I'm going to support religious liberty by supporting these groups, it really makes a difference when you have the heavy hand of government, whether it was the Obama administration or in this case, the Pennsylvania Attorney General, using taxpayer dollars to go after these people's rights of conscience. It's important that we stand up and make a difference. And I just want to take this opportunity to, number one, thank the organizations that are out there doing it, but even more than that, to thank the people that support it as well. You were talking about the coercive nature or using the Religious Freedom Restoration Act as a sword rather than a shield as it was intended. And it made me think, just generally speaking, about the coercive nature of those who are promoting, in my view, this pro-abortion perspective. When I think back to the arguments that were made in the Conestoga Wood case, I was there in the courtroom and heard, I believe it was Justice Roberts, ask the Solicitor General then for the Obama administration, Solicitor General Verrilli, said, would it be your position, it sounds like you're arguing, would it be your position that the government could force taxpayers to actually fund abortions? And he said, well, that's not an issue at this case. And I think Robert said, it's exactly that. But then he went on to say, well, it would. Our argument basically would be, we would be able to do that. And then we see the same thing with Josh Shapiro and everything else, pushing an agenda. And when Justice Alito, in his decision in the Conestoga Wood Hobby Lobby case, and he's describing the Hahn family, and very meaningful decision. I encourage people to read Alito's opinion. But he said, the government, in effect, this is not a direct quote, but basically what the Hahn family believed that what the government was forcing them to do or trying to force them to do was for them sin. And that the government was trying to force someone to sin. And when it's put in those plain terms, it really, when you think of rights of conscience and other things, when you think of it that government is forcing people to sin, that puts this in a real black and white perspective.
It does. Our founders understood that. I've been recently rereading James Madison because I'm putting together a friend of the court brief for the Supreme Court in another matter, talking about religious liberty. But there's this sense among many that religious people are weaponizing religion in order to basically manipulate the law. Madison's view was very different. He talked about people being subject to two sovereigns, the sovereign being the state and the sovereign being whom he called the creator or the universal sovereign, the creator of the universe. And we shouldn't treat people as lawbreakers because they're haplessly stuck between these two sovereigns. Instead, it's the duty of the civil magistrate to make room for the religious believer, which is precisely what HHS did. They recognized that we need room for the believer to not violate their conscience, which is what's so powerfully beautiful about HHS's actions right here.
In the Trump administration,
yeah.
HHS did the opposite in the Obama administration with these mandates.
Yes.
Under the Trump administration, to actually grant the liberty that we all thought was part of our First Amendment rights. To, again, I'm a non-lawyer, so I don't want to be quoted as citing the wrong amendment or something, but I understand, at least in simple views of most American citizens, would say the First Amendment allows me this right of conscience. And then we have the Religious Freedom Restoration Act, which was passed overwhelmingly in the Clinton administration, and yet suddenly we see many in political office, like our Attorney General here in Pennsylvania, tossing those things aside, seemingly in the Commonwealth of Pennsylvania, which was founded on the premise of religious liberty, which is populated with people who fled tyranny from other lands, and then to know that it's Pennsylvania versus the Trump administration, Pennsylvania versus Little Sisters of the Poor, just seems so contrary to our history and heritage as a nation. Anyway, I'm taking too much time away from the attorneys, so I'll let you continue the conversation, Randy.
Well, I just wanted to thank you again, Matt, for the work that you're doing for the Trump administration and what the Trump administration did with fixing this. Because as you had mentioned earlier, when the Zubik case, when the last Little Sisters of the Poor case went up to the Supreme Court basically admonished the parties, hey, can't you guys figure out a way to work this out? And the Obama administration was unable to do that, but certainly there's a simple solution, which is if people have a religious problem with that, give them room, because as you mentioned earlier, there are millions and millions and millions of people who are not covered by this mandate. Why is it that we need to cover those who are in question here? And I forget which of the justices brought this up. I can't remember precisely, but they wanted to know how many people would be affected by this. And it was maybe 70 to 100,000 people who would be affected by this exemption and tell me if I'm wrong, when there are at least 100 million Americans not covered by the mandate for other reasons.
Yeah, there are a lot, and the number changes, but what the administration explained in the rule when it was both times it was published was this is a rule that the mandate for coverage is still in place. It's still in place in 99% of cases, but you have a very small group of either religious organizations or organizations with moral convictions, which is even a smaller group of those who can't provide this coverage. There are even some entities that brought cases against the Bowman administration. They're nonprofit entities whose mission is in part to oppose certain of these items that can cause abortifacient effects, and they only hire people who agree with those beliefs. And what the Trump administration said, which is in the rule in the 2018 rule on protecting moral convictions, is that the government has not just not a compelling interest with respect to those organizations, it has no interest at all. What is the interest to make an organization who on principle opposes these items, and all of whose employees oppose these items and aren't going to use them, to cover them anyway? So the Trump administration recognized that, and yet we heard at the Supreme Court last week, these plaintiffs are saying no, the Trump administration must force those entities to have this coverage, even though it violates their moral convictions. And it's a disturbing thing. It's one thing for the government to violate beliefs, as you sort of saw in your case, and for people to have to go into court and say, no, we have constitutional and statutory religious freedom protections, and to get a court to protect them. It's another thing for the government to say, you're right, we don't want to violate your beliefs anymore. And then a third party comes in this case the states, and says, no, you must violate their beliefs.
Even when
you cannot leave these people alone. You must coerce them. It is not acceptable for you to not violate these people's beliefs. That's the posture in this case, and it is puzzling to many people.
I'll just say this myself. That's the posture of Pennsylvania's Attorney General. Randall?
And it raises a larger issue about liberty. And as I've had talks about liberty in places like the Pennsylvania Bar Association, where their view of what's fair and good and what makes a good society may not always be the same as mine. But there seems to be this view so often that, liberty is a good thing if it's the kind of liberty that I would want. But really, government policies that are being put in place are really good policies, and it's only morons who would disagree with it. And so everybody should really get part of the program, and we can force them to be part of the program, and everything's going to be fine, because that will help in our process of enlightening folks to get with the program. And it misses the fact that, one, the shoe eventually is on the other foot, right? And we need to be careful when the political winds change to make sure that our liberties are in place, and not just say, hey, if my people are in charge, let's not give quarter to people who disagree. We need to do that on the whole, but we also forget that for many, it's not just an issue of we can force and punish people into complying. What we end up doing is forcing and punishing people out of the political community as a whole. So, for instance, on a case I'm working on right now, where Catholic Social Services no longer can place children for adoption or foster care, because they don't want to violate their deeply held religious beliefs about what marriage is. You can't force certain entities to comply, and isn't it better to work with people in the ways that we can, rather than to punish them out of actually helping, in that case, to place children for care, or with Little Sisters of the Poor? There's a lot of good works that they do that they would curtail rather than violating their conscience. And we forget about those effects. Sorry for grandstanding there, Michael.
I don't know if you want to comment, Matt. I have some questions from the audience if you're ready.
Go right ahead.
Both of you. This is one says that given the weak and strange arguments being made by the states and the strong rebuke the Supreme Court gave lower courts in recent religious liberty cases, what recourse would or should the Little Sisters of the Poor have for court costs and hassles? So I guess the question is, if they come out victorious, do they benefit they've been through misery, but do they get some court costs or other payments made to them?
Well, when you win a civil rights case, there's fee shifting, where the fees that your attorneys charged you end up getting paid by the government. And even if the attorneys are doing the work for free, the value of that time ends up going to the attorneys who were donating their time. What's unfortunate, though, is there's often folks who are trying to protect their religious liberties and can't quite make it to the end. And there were numerous cases like Hobby Lobby and Conestoga Wood, for instance, that where there were losses along the way. And unless you hang into there to the end and get the victory, sometimes it makes tough going. The good news is that there are groups like Alliance Defending Freedom that Matt used to work for, or even our law center, that provides our services free of charge. So it gives an opportunity for groups to be able to take that challenge, rather than thinking, I may have a $500,000 attorney fee bill by the time I take this all the way up to the Supreme Court, which is a big detriment to a lot of people who are trying to vindicate their rights.
These cases like this one, or Matt, I don't know if you want to comment on that as well, related to, I guess Randy's explained about the potential for payment that ends up happening.
Oh, I'm not in that business anymore, Michael.
Okay. And Randy, maybe you might know this, is in the case of Pennsylvania versus Trump, in this case, in Little Sisters of the Poor, is that the taxpayers of Pennsylvania that ultimately end up paying that because the lawsuit was brought by Pennsylvania Attorney General?
Yes. Yeah. How do you like that? You get to pay for that through your tax dollars. So it's the Pennsylvania Attorney General that is spending the time suing the Trump administration, and then Little Sisters of the Poor intervening in the case. If they're successful, their attorney's fees could get paid for. But in any case, the people of Pennsylvania are out by really pursuing a path that's against religious liberty, and we have to pay for it too.
Paid for it on both ends, both in the bringing the case, and then if the Little Sisters of the Poor, the Trump administration ends up victorious, which we pray that is the case, paying for it at that end as well. I want to ask both of you, maybe you can comment a little bit about what I would view, just having been close to the Conestoga Wood case and knowing the Hahn family. If I remember their circumstance and these numbers correctly, the Hahn family in that Conestoga Wood case had, for the history of their company, provided very robust benefits for their employees, and their Christian love and concern for their employees, which I think at the time of that lawsuit, they had about 1,000 employees, have provided very good healthcare coverage and other benefits for the employees. Under the Obama, the HHS abortifacient contraceptive mandate, they were given a couple of options. They could abandon coverage for their employees entirely and put their employees on the Obama, the Affordable Care Act exchange, in which case then they would have to pay a fine to the government of $1 million. But if they decided to keep the health insurance that they paid for their employees, or the coverage that they had for their employees, but did not provide this coverage, the fine was $36 million, $100 per day per employee, $36 million, which would have put them out of business in very short order. I just wonder if you can comment on those distinctions there, because in both cases, they could ostensibly avoid paying for it, maybe assuage their conscience, but ultimately it seems coercive of the government. They were not only just wanting this coverage, but they wanted to force employers in a very severe way in the coercion. I wonder if you want to comment on
that. Yeah, I mean, it was clearly lopsided. It was clearly policy motivated, not motivated in terms of, hey, we need to make sure that people have really good health care, because you're providing all of this coverage, but just this little tiny piece, and you have a $36 million fine versus the lesser fine. But I remember too, sitting in the courtroom, and one of the justices had raised the issue of, hey, what's really the big deal? What is the harm to Conestoga Wood or to Hobby Lobby in just discontinuing their health coverage and paying the fine for completely discontinuing the health coverage? Because after all, the fine will cost less than the health insurance. And just stop and think, oh, but the economics of it are the business owners don't give health insurance in order to avoid fines. They give health insurance to attract the best employees that they possibly can. So then they have to pay the fines, and they have to pay money to their employees to be able to afford their own health coverage that's not going to be as affordable as getting through a group plan, and they have to pay for it with after-tax dollars. And there's no burden to the Hans. How can this be? What world is this where this is no burden? Thankfully, the court understood that yes, indeed, the fines are a burden to the Hans, and this should not continue.
Well, we're coming up near the top of the hour. I just wondered, first, Matt, if you had any comments related to other cases you may be involved in that you thought the public ought to know about, or the Trump administration, in terms of fighting for the sanctity of life or religious liberty, that you'd like to draw our attention to.
Well, certainly. You can go to not only whitehouse.gov, but hhs.gov. You can find lists of the Trump administration's pro-life accomplishments, as well as its activities to keep President Trump's promise to protect religious liberty. So Google any of those words, and you'll come up with a large list of things. Here at HHS's Office for Civil Rights, we wanted to make sure that religious liberty is protected across our agency for years to come. We have 80,000 employees. We spend the second largest amount of money to DOD, the Department of Defense, and so we've created a Conscience and Religious Freedom Division in the Office for Civil Rights at HHS, led by Director Roger Severino. And the purpose of that division is to make sure that conscience and religious freedom laws and protections are enforced and taken into consideration to the same extent as all other civil rights. We enforce many civil rights laws, and we also now, as an institution, enforce religious freedom and conscience laws as well. And that's just one part of many activities President Trump has taken to protect religious liberty and the sanctity of human life.
Are you aware, Matt, related to in other departments, similar sorts of working groups, if you will, or folks, I guess that's not the right way to put it, but activities in, let's say, Department of Education or in other areas where the same sorts of staffing and efforts are being made on in the same regard?
There are a lot of other activities going on. Every agency faces a little bit of a different situation in terms of their staffing, but we certainly are in touch with not only President Trump's staff at the White House, but with our colleagues in other agencies. The Attorney General, General Barr, has been very vocal in support of religious freedom in general and the Religious Freedom Restoration Act specifically, as has President Trump with the executive orders he's issued, and President Trump's Office of Management and Budget. They issued several religious liberty announcements in January. And you can find all these online, but it's our goal to continue to build up the infrastructure necessary to protect our first freedoms, religious freedom.
When one thinks of the Statue of Liberty there in the New York Harbor, or just the notion of as President Reagan described our nation as a city set on a hill, and just the religious liberty being such a chief and key component of that, to see this defense of religious liberty so vigorously defended and protected in the Trump administration is wonderful, but it's also going on even overseas with the efforts with the Secretary of State and with Mike Pompeo and the efforts on international religious liberty. And it's just really something. It's an untold story in the minds of many, I think, for a variety of different reasons. We want to salute you for the work that you're doing, Matt, there at the Department of Health and Human Services. And we're very happy to be able to help tell that story here as well. And again, salute you and your efforts and the department in defending Little Sisters of the Poor and religious liberty and the sanctity of life against Pennsylvania's efforts to try to squelch it. Randy, I don't know if you have any closing comments that you want to make or any other questions before we wrap.
I'm just glad that you were part of the beachhead team. I think that's the way that you put it, on the earliest days of the administration, to be able to work on these issues. So we're grateful for the work that you do.
Thank you both. It's been an honor to serve the administration, and it's been a pleasure to join you today.
Thank you very much. For those who want further information about our work at the Pennsylvania Family Institute or Attorney Wenger with the Independence Law Center, you can always go to our website at PAFamily.org. That's PAFamily.org. And the website for Independence Law Center, Randy, is?
IndependenceLawCenter.org.
IndependenceLawCenter.org. So you can get more information. And Attorney Matt Bowman, one more time for, you said whitehouse.gov, but then HHS and your department, is there a website people can look things up related to HHS?
Yes, just type in HHS Office for Civil Rights, and you'll find us very easily.
Well, that's great. Well, let me thank our guests again for being with us, and I'm going to close in prayer. Heavenly Father, we thank you, Lord, for your goodness, for your mercies. We pray, Lord, for our nation and its leaders, President Trump, and for our state here in Pennsylvania, for Governor Wolf and all those who are put in positions of authority and to lead. We pray, Lord, that your wisdom would be given to them, especially as they navigate through this challenge that we're going through, the coronavirus pandemic. We do thank you for Matt Bowman and for the team that you've assembled there at the Department of Health and Human Services, that you would help them to work wisely and efficiently and effectively in defending American principles and constitutional values. We thank you, Lord, for this time that we've gathered here, and pray your blessing on our nation. In Jesus' name we pray. Amen. Thank you all so much, and we will be in touch with you with our next webinar. And I will mention one that we have coming up, which is Monday, May 18th. Monday, May 18th was the date scheduled for the Pennsylvania March for Life, which because of the pandemic has been postponed. Lord willing, it will happen in the fall, but we are having a gathering, Pennsylvania March for Life, Log In for Life it's called. And we have Ryan Bomberger from the Radiance Foundation and representatives from the from the National March for Life organization that has that wonderful march every January in Washington, D.C. They'll be on the call as well. And our friends at the Pennsylvania Catholic Conference will be joining us too. It's going to be an informative time. That's live at lunch, Monday, May 18th. We hope you'll join us, and you can always find out information about that webinar and other things that we're doing at Pennsylvania Family Institute at PAFamily.org. Thanks, God bless, and we'll see you soon.